One of the most difficult calls I receive from families starts with a question like this. My mom has dementia and can't manage her finances anymore. What do I do? Or, my dad is in the hospital and the doctors say he can't make medical decisions for himself. How can I help? These situations are emotional, stressful, and often happen when families are already dealing with a health crisis. Hi, I'm Kristine Romano, founder of Kristine Romano Law. Today I want to explain what options may be available when a parent can no longer make decisions for themselves, including guardianship, conservatorship, and how the court process works in Massachusetts. Before anyone rushes to court, the first question is, did your parent already complete estate planning documents? If they signed a valid, durable power of attorney, healthcare proxy, living trust, while they still had legal capacity, these documents may allow trusted individuals to step in and help without court involvement. In many cases, these documents can avoid the need for guardianship or conservatorship entirely. That's one of the reasons proactive planning is so important. However, if those documents don't exist, or if they're no longer sufficient, the court may need to become involved. A guardianship is a legal arrangement where the court appoints someone to make personal and medical decisions for another adult. This may include decisions about healthcare, living arrangements, daily care and support, safety and well-being. Guardianship is typically considered when an individual can no longer make informed decisions about their own care because of conditions such as Alzheimer's disease, dementia, serious cognitive impairment, brain injury, and certain mental health conditions. The guardian's role is to act in the person's best interests and ensure their needs are being met. A conservatorship is different. While guardianship focuses on personal and medical decisions, a conservator is responsible for financial matters. A conservator may be authorized to pay bills, manage bank accounts, handle investments, protect assets. Sometimes a person only needs a conservator, sometimes only a guardian. And in some situations, the same individual may serve in both roles. The court determines what level of authority is appropriate based on the person's specific circumstances. Court intervention is usually necessary when no power of attorney exists, no healthcare proxy exists, existing documents are invalid or unusable, family members need legal authority immediately, financial institutions refuse to honor existing arrangements, or medical providers require court-appointed decision makers. Without legal authority, even close family members may be unable to access accounts, make medical decisions, or manage important affairs. Many people assume that being someone's child automatically gives them rights. In reality, it usually does not. The guardianship or conservatorship process begins by filing a petition with the court. The court then reviews evidence showing that the individual is unable to manage some or all aspects of their personal or financial affairs. This often includes medical evaluations, physician reports, supporting documentation, and information about the proposed guardian or conservator. The court's goal is to balance two important priorities: protecting vulnerable individuals while preserving as much independence as possible. Because of that, the court may grant limited authority or broader authority depending on the circumstances. Once appointed, guardians and conservators have ongoing legal responsibilities and may be required to provide reports to the court. One common misconception I frequently hear is, I'll just sign the documents for my parent. Unfortunately, once someone loses capacity, they can generally no longer create a valid healthcare proxy or power of attorney. That's why waiting too long can create significant implications. Another misconception is that guardianship automatically gives complete control over every aspect of someone's life. In reality, Massachusetts courts often tailor guardianships and conservatorships to meet the person's specific needs while preserving as much autonomy as possible. Many guardianship cases could have been avoided if planning documents had been completed earlier. A properly drafted power of attorney and healthcare proxy can often save families significant time, expense, and court involvement. But when those documents aren't available, guardianship and conservatorship can provide an important path forward. At Kristine Romano Law, we help families navigate difficult transitions with compassion and practical guidance. Whether you're trying to determine if guardianship is necessary, seeking conservatorship for a loved one, or hoping to put planning documents in place before a crisis occurs, we're here to help. Contact us today to schedule a consultation and learn what options may be available for your family's situation. The right guidance can make a challenging situation much easier to navigate.